When my wife and I pulled into our driveway after our honeymoon, she thought the GPS had made a mistake. I thought we had taken the wrong turn. Because where my front pasture used to be, a 20-foot-tall stone wall now stretched across the edge of my property. Fresh concrete, brand new steel gates, decorative lighting, an enormous bronze sign bolted into the stone. Welcome to Cedar Ridge Estates, private resident access. My wife looked at me. Ethan, didn't your family's fence used to be there? I nodded slowly. It did. She stared at the wall. So, why is someone else's neighborhood entrance sitting on your land? That was an excellent question. An even better one was this. Why had every driveway leading into the HOA subdivision been built through the exact strip of land my grandfather had refused to sell 30 years earlier? 6 weeks later, that same entrance would be surrounded by county surveyors, construction inspectors, sheriff's deputies, and one very unhappy HOA board, because they were about to discover something expensive. The only legal access road serving their entire subdivision crossed property they did not own. And unlike them, I had paperwork. My name is Ethan Carter. I'm 39 years old, own a heavy construction company, and inherited our family's ranch just outside Redstone County 3 years ago. The ranch wasn't enormous, about 400 acres, enough pasture for cattle, enough woodland for hunting, enough privacy that I never expected to have problems with neighbors. Then Cedar Ridge Estates expanded. At first, we got along fine. The HOA stayed on its side of the property line. I stayed on mine. Everyone was happy. Then I married my best friend, Lauren. We decided to spend 2 weeks in Alaska for our honeymoon. Before leaving, I walked the property one last time. Everything looked normal. The old split-rail fence marked the boundary exactly where it had stood for decades. I even waved to a grading crew working near the neighboring subdivision. One worker shouted, "Have a good trip!" "We will." I had absolutely no idea what they planned to do while we were gone. 14 days later, we returned. The first thing I noticed was construction equipment. Bulldozers, concrete mixers, landscaping crews, then the wall, massive stone columns, decorative iron fencing, automatic security gates, fresh asphalt leading directly into the HOA. Lauren whispered, "Ethan, please tell me this isn't what I think it is." I parked the truck, walked to the wall, placed my hand against the new stone, still warm from the afternoon sun. Then I looked down. Our original survey marker was sticking out of the grass, 3 feet inside the wall. I smiled, not because I was happy, because whoever built this had made an unbelievable mistake. The wall wasn't close to my property. It was undeniably on it. A security guard walked out from a small booth built into the entrance. "Can I help you?" "You certainly can." "How?" "Who authorized construction on my property?" He frowned. "This belongs to Cedar Ridge Estates." "No." I pointed toward the survey monument. "It belongs to me." He laughed politely. "I think you're mistaken." "I don't." I took several photographs, measured distances using my survey app, recorded videos, then drove home. Lauren looked at me. "Aren't you going to argue with them?" "No." "Why not?" "Because arguments disappear. Evidence doesn't." The following morning, I called the county survey office, then my attorney, then my construction superintendent. Within 48 hours, licensed surveyors were on site. They uncovered every original property monument, installed new stakes, used GPS equipment accurate to less than an inch. The final survey wasn't even close. The HOA entrance wall extended 37 feet onto my ranch. Its decorative landscaping occupied nearly an acre of private property. The access road crossed another 60 feet. My attorney, Rebecca Lawson, quietly looked over the finished survey. "They're in serious trouble." "That bad?" She nodded. "They didn't just build over the line. They built their only entrance across it." That stopped me. "What do you mean?" She spread the subdivision plat across the table. The original emergency access road had been closed years earlier after flooding. The new entrance, The beautiful one built while I was on my honeymoon had become the neighborhood's only usable vehicle access. Every resident, every delivery truck, every school bus, every emergency vehicle used that road, which crossed my land, legally, without permission. Rebecca smiled. I'm guessing no one checked the final survey. I'd say that's a safe assumption. 3 days later, we attended the next HOA board meeting. The president introduced herself. My name is Linda Marshall. I'm Ethan Carter. What can we help you with? I handed her the survey. You built your entrance on my ranch. She barely glanced at it. Our engineers handled everything. I've already spoken with county surveyors. They're mistaken. They're licensed. So are ours. I slid another folder across the table. This one comes from the county. She didn't open it. Instead, she smiled. We've invested over $3 million improving that entrance. I'm aware. It isn't moving. I looked around the room. Several board members seemed uncomfortable. One finally asked, Linda, did we verify the property boundary? She answered immediately. Our contractor handled it. That wasn't an answer. It was an assumption. The meeting ended without resolution. As we walked toward the parking lot, an elderly resident quietly caught up with us. Mr. Carter? Yes? I helped build this neighborhood 25 years ago. You did? He nodded. There used to be another road. I know. So why'd they build this one? He looked back toward the entrance. Because it was cheaper. Cheaper than what? Buying the land. Lauren and I exchanged glances. What exactly do you mean? The old man sighed. I heard developers talking years ago. They couldn't reach an agreement with your father. So, they built anyway. That single sentence changed everything. The issue wasn't a surveying mistake. Someone may have knowingly chosen to build first and worry about ownership later. The next week, my attorney requested decades of county planning records, construction permits, road approvals, environmental studies, meeting minutes. What we found shocked even the county engineers. Buried inside a 30-year-old planning file was a handwritten note from the original project engineer. One sentence had been highlighted. Final access easement not secured. Do not begin permanent entrance construction until ownership issues are resolved. Rebecca slowly looked up from the document. They ignored it. I think they did. No. She pointed to another signature farther down the page. They knew. I leaned closer. The approval signature belonged to the original Cedar Ridge Development president. Directly underneath, someone had written 3 words in blue ink. Proceed anyway. Rebecca closed the file. Ethan. What? I don't think this is just a property dispute anymore. Then what is it? She looked directly at me. I think we just found evidence that someone knowingly authorized construction on land they didn't own. Outside the office, I looked toward the distant stone wall standing across my family's ranch. It had taken them 2 weeks to build it while we were away. They believed it would stand there forever. They had no idea that I owned the construction company capable of building retaining walls, security barriers, and access roads faster than almost anyone in the county. And before long, the HOA would discover that blocking someone else's property can become a very expensive mistake, especially when the owner knows exactly how walls are built. The Monday after our attorney uncovered the 30-year-old planning records, the county scheduled an official site inspection. Not because I demanded one, because the documents raised questions that county engineers couldn't ignore. By 8 o'clock that morning, my ranch looked like a construction conference. County surveyors unloaded GPS equipment. Engineers carried rolled-up blueprints. Environmental officials inspected drainage channels. Sheriff's deputies parked nearby to keep traffic moving. Across the road, dozens of HOA residents gathered to watch. Everyone wanted to know whether the rumors were true. Linda Marshall arrived wearing sunglasses and carrying a thick binder. She walked directly toward the lead surveyor. This inspection is unnecessary. The surveyor smiled politely. The county disagrees. Our engineers already completed this. We're reviewing the official property boundaries. Linda crossed her arms. Those boundaries were settled years ago. The surveyor looked down at the original subdivision plat. No, they weren't. For the next 3 hours, nobody argued. The survey crews simply worked. Laser equipment measured every angle. Historic survey monuments were uncovered. Old steel pins buried beneath decades of soil were located with magnetic detectors. Every measurement confirmed exactly the same result: the decorative entrance wall, the security gate, the landscaped median, the visitor parking lane, and nearly the entire access road had all been constructed on my family's recorded property. One county engineer quietly shook his head. I've never seen an entrance this far off the approved alignment. Linda finally spoke. There has to be a mistake. The surveyor handed her the GPS printout. There isn't. She barely looked at it. Instead, she called the subdivision's engineering firm. An hour later, their lead engineer arrived. He reviewed the county measurements, then compared them with his company's archived records. His face slowly changed. He looked toward Linda. Can we speak privately? They stepped away from the crowd. Even from a distance, I could tell the conversation wasn't going well. Linda's confident posture disappeared. She repeatedly shook her head. The engineer eventually walked back toward us alone. I've completed my review. And? Asked the county official. Our firm designed the entrance according to the approved plans. He pointed toward the wall. This isn't where we designed it. The crowd murmured. What do you mean? Linda demanded. He unfolded the original engineering drawings. The entrance shown on the plans sat almost 40 feet farther east, entirely outside my property. The wall built during my honeymoon wasn't simply misplaced. It had been relocated after the engineering plans were approved. The county engineer frowned. Who authorized the field change? The contractor answered honestly. We don't know. The silence that followed seemed to last forever, because everyone understood what that meant. Somebody had changed the construction location, without updating permits, without recording revised surveys, without obtaining permission from the property owner. Later that afternoon, Rebecca and I met with the county planning director. He placed several folders across the conference table. We've reviewed 30 years of records. And? There has never been a recorded easement across your ranch. No temporary easement? No. No purchase agreement? No. No condemnation action? None. He leaned back. As far as county records are concerned, the HOA entrance should never have been built where it currently sits. That evening, the HOA board called an emergency meeting. Residents packed the clubhouse. Some looked angry, others looked worried. Many simply wanted answers. Linda opened the meeting. The county inspection is still preliminary. A homeowner immediately stood. My mortgage company called today. They heard about the investigation. Another resident added, my insurance agent asked whether our neighborhood still has legal access. Questions started coming from every direction. Can emergency vehicles still enter? Will property values drop? Who's responsible? Linda tried calming everyone. We're exploring legal options. At that moment, Rebecca quietly entered the room. She wasn't a resident, but she had been invited by the county attorney to deliver an official notice. She handed a sealed envelope to the board. Linda opened it. Her expression changed instantly. What is it? Someone asked. Rebecca answered before Linda could. The county has temporarily suspended approval for any additional construction involving the entrance until ownership issues are resolved. The room became silent. Then Rebecca continued. My client has also formally requested immediate removal of all structures located on his property. Linda looked shocked. That's impossible. Rebecca remained calm. My client prefers an amicable solution. But ownership rights remain ownership rights. After the meeting ended, dozens of residents approached us. Most weren't angry. They were frustrated. One elderly man sighed. "I've lived here 20 years. I had no idea that entrance wasn't ours. Neither had most of the neighborhood." The following week, something unexpected happened. Instead of negotiating, the HOA filed a lawsuit asking the court to recognize permanent access rights across my property. Rebecca smiled after reading the complaint. They're asking the judge to give them land they never bought. Can they? Not based on what I've seen. During the preliminary hearing, the judge reviewed the surveys, the historical planning records, the engineering drawings. Then he asked the HOA's attorney one simple question. Can you produce a deed, easement, purchase agreement, or other document granting your client the right to occupy Mr. Carter's property? The attorney searched through his files, finally answered, "No, Your Honor." The judge nodded. Then the court encourages both parties to continue settlement discussions. Outside the courthouse, reporters gathered. The story had become local news. Not because of me, because hundreds of homeowners suddenly realized their only neighborhood entrance might have been built in the wrong place. A few days later, Rebecca visited my construction office. She spread several drawings across my desk. "What are these?" "My engineers prepared them. I studied the plans. A retaining wall, drainage improvements, new fencing, security barriers, all entirely inside my property line. Every permit already approved by the county." I looked at her. "This is legal?" She nodded. "Every inch." "But what happens to the HOA entrance?" Rebecca smiled carefully. "That's their decision." "I don't understand." "If they continue occupying your land, they'll interfere with your permitted construction. And if they remove their entrance, they'll have to build a new one. Either way, the decision belonged to them, not me." Word spread quickly that heavy equipment had been scheduled to arrive at my ranch the following Monday. Residents lined the roadside before sunrise. Television news crews appeared. Even county officials returned. Everyone wanted to see what would happen. At exactly 7 o'clock, the first bulldozer rolled through my gate. Behind it came concrete trucks, excavators, survey crews, and more than 40 construction workers wearing my company logo. Across the road, Linda stood frozen beside the HOA entrance because she had just received one final letter from Rebecca. It wasn't a threat. It wasn't a lawsuit. It was something much simpler. A copy of my county-approved construction permit, showing that my new retaining wall would be built entirely on my land, exactly where the HOA's unauthorized entrance currently stood. And unless the HOA acted immediately, their own entrance would become the obstacle standing in the way of a completely lawful construction project. By 7 o'clock Monday morning, my construction crews were already on site. Not to block anyone, not to trap an entire neighborhood, but to begin the retaining wall and drainage improvements that had been fully approved by the county months earlier. Every survey stake had been inspected. Every permit had been issued. Every inch of the project stayed entirely inside my own property. Across the road, dozens of Cedar Ridge residents watched in silence. They weren't angry anymore. They were worried, because they finally understood the real problem. Their only entrance had been built on land the HOA didn't own. At 8:15 a.m., Linda Marshall rushed onto the site with the HOA's attorney. "Stop the work." I looked toward Rebecca. She answered calmly, "My client is working on his own property." Linda held up a stack of papers. "We filed for an emergency injunction." Rebecca smiled politely. "And the court denied it 30 minutes ago." The attorney quietly nodded. "The judge found no legal basis to prevent construction that complies with county permits." The atmosphere changed immediately. County engineers stepped forward. They marked the exact property boundary once more. The lead surveyor addressed everyone. "The retaining wall shown on these plans remains entirely within Mr. Carter's property." He then pointed toward the HOA entrance. "The entrance improvements extend beyond that boundary." No one argued, because every measurement had already been verified 3 separate times. By noon, The county planning director arrived with another document, an official notice of violation. The county ordered the HOA to remove every unauthorized structure located on private property and submit a compliant access plan within 90 days. If they failed to comply, daily civil penalties would begin. Residents turned toward Linda. One homeowner finally asked, "Why didn't we just buy the land years ago?" No one answered. The following week, mediation began. For 2 full days, engineers, attorneys, county officials, and HOA representatives reviewed every possible solution. The county rejected any proposal that relied on occupying private land without consent. Eventually, an agreement was reached. The HOA would build a brand new entrance entirely on land it legally owned. The unauthorized wall, landscaping, gate, and roadway crossing my ranch would be removed at the HOA's expense. All restoration costs for my property would also be paid by the association's insurer. Construction took 4 months. The old entrance disappeared piece by piece. Once the concrete was removed, our ranch looked the way it had before our honeymoon. The original fence was rebuilt, native grass was replanted, new trees replaced those that had been removed during the unauthorized construction. When the work was complete, county inspectors issued a final report confirming that the property had been restored. At the HOA's annual meeting, homeowners elected an entirely new board. Independent engineering reviews became mandatory for future capital projects. Every major construction decision required legal verification of property ownership before work could begin. Months later, Lauren and I stood near the rebuilt fence at sunset. She smiled. "You know, this view is even better than before." I laughed. "I think you're right. What changed? The fence?" She shook her head. "No, the lesson." She was right. The dispute had never really been about a wall. It was about something much simpler: respecting property rights, checking the facts, and remembering that shortcuts often become the most expensive path of all. The HOA didn't lose because someone outsmarted them. They lost because they built first and verified later. And that mistake cost them far more than buying the land would have in the first place. If you enjoyed this story, don't forget to like, share, and subscribe for more original HOA stories with satisfying legal endings and community justice. Turn on notifications so you never miss the next story. Thank you for watching.